So what we're sharing today is not an endorsement of legal advice. The hosts are not giving legal advice. This is their experience only. There's information that's shared here that is going to be under the fair use and also for journalistic and criticism purposes only. So with that said, Jay, the floor is yours. Thank you.
Well, thank you for showing up today. Hope you enjoy this segment. I sent in three video segments, and we're going to be talking today about Title II. And what I usually and customarily enjoy doing and am trained to do is to go into court and tell judges that they have to give the client ADA access, and they can't coerce, intimidate, threaten, or interfere. And also they do not have immunity. Of course, this makes everything really awkward and uncomfortable. And for me, it's enjoyable. For them, it's not. And so we're going to experience a little bit of that today. So I guess I'll let Greg, if Greg wants to cue up that first segment, this is going to, let me lead into it. It's going to be me. I was advocating for a client. This was back in 2018. And I was in Portland, Oregon, and I was doing this on the phone. You're going to hear me breathing heavy because I'm pacing around a park when I'm doing this. And I like to walk when I talk, but this judge and I got into it, and she tried to accuse me of unauthorized practice of law. Let's see how that goes.
As an ADA advocate, you may have to assert rights for a disabled person, even in court. 42 U.S. Code 12203 allows you to aid and encourage someone in the exercise of their rights. If you're pursuing their ability to have equal rights, you should not have to be bullied by a judge. With that said, judges hate to be told what they have to do, and so they often attempt to intimidate with a claim that what an ADA advocate is doing is unauthorized practice of law. They do this to intimidate you into silence. Here's one judge's attempt to do this.
This is Judge Lynn Tepper. Who do I have on the phone?
This is Jay Shore. I'm a certified ADA advocate. I'm here on behalf of...
And, sir, are you a licensed attorney?
I'm not a licensed attorney. I don't have to be for what I'm doing.
I understand that, sir. I just wanted to be clear because some of the paperwork we have been receiving in email form appears to be practicing law. I just wanted to be clear for the record, you are not an attorney, but you are an ADA advocate. Is that correct, sir?
Some of the paperwork you've received from me appears to be practicing law?
Emails, yes, sir.
Okay, well, I mean, if you want to go ahead and put that on the record and testify to that, I'd be glad to cross-examine that.
Sir, I don't think you'll be cross-examining anybody. You are not a party to these proceedings.
If I'm going to be accused, I'll be cross-examining.
You can listen while we go around to the room as to who is here. So we have established that we have court reporters from each side, and I arranged yesterday at the late minute.
Like, I want to hear from you, Mom. I want to hear from you, Dad.
Judge, may I ask why the client's ADA rights have not been honored and equal access has not been obtained?
What do you mean, sir?
I sent a notice off to Mr. Cooperwriter on 22nd,
What are you asking for?
invoking the ADA and asking for reasonable modification for...
Modification are you asking for?
It's in writing. Mr. Cooperwriter has it. He's the ADA coordinator, correct?
I'm orally asking you. What are you asking for? What modification?
Okay, to discuss the client's disability in front of the plaintiff is coercion and intimidation, and is forbidden by 42 U.S. Code 12203B. You're with notice. I've asked for a private, administrative, ex parte to discuss ADA access, and it has been denied so far. So I'm making notice of it on the record.
Thank you.
The author that I talked with on the phone, that I spoke with on the phone, is William D. Gorin, and he is an attorney that has written the book that the American Bar Association sells called Understanding the ADA. Now, this is his 4th edition, and this guy's an expert. He spent 23 years practicing the Americans with Disabilities Act field. He's a founder and current president of the National Association of Attorneys with Disabilities. So this guy, if there ever was an expert on how the ADA works, this guy is the guy. And I want you to hear what he says about how access really works.
So what are you looking for from me? I'm not sure I'm the best fit as much as I'd like to help, but I'm not sure I'm the best fit.
Can you
What are you looking for?
who do I go to hold these judges accountable so that they have to give accommodations?
So you're looking for someone who's not afraid, you're looking for a litigator that's willing to go in and take on state court systems?
There you go.
The problem that attorneys have is a lot of attorneys won't take this on because the court will fight back hard and threaten disbarment and other kinds of proceedings. So a lot of attorneys are scared to take this stuff on.
Sure.
So I didn't know before we started that we couldn't break this into segments, but so the second clip was of me going against Lisa Gorsica, a judge in Oakland County, Michigan, and she had gained notoriety 3 years prior to me coming across her path for throwing 3 kids in jail for not going to lunch with their father, who they said they saw abuse their mother. And it was just a really harsh reaction from a judge and unreasonable. And the Judicial Tenure Commission prescribed a punishment. The Supreme Court dialed that back, gave her a slap on the wrist. And here I am in her courtroom. And this client has told me that she's been beating her up for about 13 years. And so what happened with this was we got this on footage. We filed a complaint with the Judicial Tenure Commission. Judicial Tenure Commission said, we're going to have a confidential investigation. I recorded the call, which they said at the end of the call I could have done. But they didn't want me to do it. They want to keep all of this under wraps. There's a confidentiality that they want for their judges, because honestly, they don't want people having the knowledge that judges can make mistakes. They see judges as above reproach, and it's time for that to end. And so it's time for us to hold judges accountable. I was at a conference about a couple months ago, and there were 300 or so lawyers in a room, and one of the lawyers stood up and said, it's time to start admitting that judges need to be held accountable. And this was a really rogue statement for an attorney to say, because as Mr. Gorin said in this clip, judges are, if you go against a judge, it's basically a suicide march for an attorney. I mean, and Don's nodding, and I mean, this is accurate. And so it's one of the reasons we need ADA advocates is because an advocate can go in and say, Judge, you have to do this, 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 and this. You cannot claim immunity because 42 U.S. Code 12202 takes it away from you. So does Tennessee versus Lane. And at that point in time, they can't say, well, I'll have you disbarred. Well, I had a troll clip that I used to run on some of my videos where a person in one of the videos that was trolling me said he can do things that would get attorneys disbarred. And I said, yes, because I have to tell judges on a regular basis that they're going to be held accountable. They don't have any immunity, and they can't coerce, intimidate, threaten, and interfere. And that's all they do. So this is what happens when you go into court and try to get ADA access for somebody. Usually the client is going to be facing this on their own. They're going to be, I consider it abusive. I consider the court Karen Huffer, my mentor and trainer, spent 35 years documenting what she coined as legal abuse syndrome, wrote a book called Legal Abuse Syndrome. And it's about when people go into the system and expect fairness and justice, and the system says, no, we're going to do this our way. And if you don't like it, guess what? You can appeal, you can do this, you can do that. By the way, you get to buy the law. And I'm sorry that I'm saying this, because that's kind of how it works. And if we can make the system more accessible, maybe we can build a bridge between the legal industry of lawyering and people getting their rights restored. But right now it's a situation where the people who need the help the most are the most broke. They can't afford it. And so therefore they're just getting steamrolled. And this is an endemic problem And that's what we're wanting to show you today. When you go into court, Title II of the Americans with Disabilities Act. Can you bring up that blue clip that I gave you, Greg? That's got my little words on it and so forth. If you could bring that up, throw it up. Title II of the ADA, here it is. It says, coercion, intimidation, threats, and interference are prohibited under 42 U.S. Code 12203B. State sovereign immunity is removed under 42 U.S. Code 12202 and Tennessee versus Lane. And then also the court must provide privacy and independence. Now, if you remember on that clip, thank you for showing that. If you'll remember on that clip, though, when Judge Gorska, when I said, why are you not giving my client ADA access? The first thing she did, and this is predictable, I tell all my clients this, when you go into court and tell a judge, if you're put in a position where you have to tell a judge on the open record that you do not have ADA access, number one, it monkey wrenches the system, and it needs to happen. So if you go into court, you don't have ADA access, say it on the record. I do not have ADA access. The next thing that's going to happen, and this is a guarantee almost, I'm just claiming it, but it usually happens. What accommodations do you need, or what disability do you have? And under 28 CFR 35.160B2, 28 CFR 35.160B2, it says that the court must provide auxiliary aids and services in a way that protects the privacy and independence of the individual with a disability. And they don't do this. They don't even know that they have to do this because they're not trained adequately. And so that question, when they say, well, what disability do you have, or what accommodations do you need? At that moment, they are again discriminating against you on the basis of disability because they're denying you your right to privacy. The other side can now use this disability information in a way that is strategic, for a strategic advantage, tactical advantage, when they have no right to that information. And a lot of judicial canons say that you can't have an ex parte hearing without giving the other side an opportunity to respond to it. Well, in ADA matters, that's not allowed, because then you've got the other side, the opposing side, somebody you're at war with, coming in and saying, oh, we need to investigate this disability thing. Well, I mean, there's the privacy pieces out the window at that point.
Right.
And so your rights are stomped on.
So Jay, I've got a question. So in terms of, so I understand why you don't have to disclose the disability, but do you not have to tell them what your accommodation is that needs to be, what you need as an accommodation?
Not in open court. No.
Okay.
Because I'm also, and I don't really talk about this a whole lot. I'm a domestic violence survivor, but I'm a domestic violence and sexual violence survivor rights advocate, and I trained at National Crime Victim Law Institute in Portland, Oregon, and they're affiliated, they're accredited, they're affiliated with Lewis and Clark Law School. And one of the things with DV and SV is that you may be in court against your perpetrator. Mm-hmm. And at that point in time, if you're discussing that you need a separation wall between you and your perpetrator, and you're having to do it in front of your perpetrator, this is not only demeaning, it's re-traumatizing, and it causes you just to be totally removed from the situation in an administrative way of access. So somebody can be sitting in court at law and automatically have their access removed and yanked from them. It's just the same. It would be like going into a courtroom and somebody's sitting there with a wheelchair or a walker, and they're standing up and leaning on that walker or sitting in that wheelchair, and you come up and you just yank it out from and drag it out of the courthouse. It's the same kind of a thing. Mm-hmm. And so, and that privacy piece has to be dealt with administratively. That's why under 28 CFR 35.107, there is a requirement for a court, if a covered entity under Title II has more than 50 employees, they have to have we call it a court, an ADA ADA coordinator. Sorry, Dawn went off the screen, it kind of threw me off for a little bit.
She might have went where I went last time. So let me follow up on this. So do you end up doing like a sidebar with the judge? I mean, how do they? I mean, they can't necessarily try to read your mind in terms of what your accommodation is, but you deal with it in a privacy matter, not in open court, correct? Is that?
Yes, and let me explain how incompetent courts and judges are. I regularly encounter, welcome back, Dawn. I regularly encounter ADA coordinators that say, we can't do this for you because it's going to fundamentally alter the way the court operates. So you're going to have to motion for this in front of a judge, which destroys the privacy piece. And so I just come back and say, look, first of all, it sounds like what you're doing is trying to give me legal advice, and I refuse that. And secondly, I will point out that there is a requirement in Title II for a designated responsible employee, and you've claimed to be that person. So you're responsible for the compliance. I've presented my needs to you. If somebody needs to motion the judge or go to the judge and talk to him about it, guess what? That's your job. And they don't like hearing that. And as a matter of fact, they will buck me most every time. And so then it becomes a matter of, if they've actually, in one case recently, I actually had a lawyer, and most of these people that are doing this for the court administratively are lawyers. If they're court administration, if they're a trial court administrator or somewhere around that level, they usually get an attorney to do that job. And then they'll slap that label on them of ADA coordinator. That's common practice. And occasionally you'll get an ADA coordinator that's not a lawyer. I don't like that either. I mean, if a lawyer's there, they're at least going to take it a little bit more seriously. But where was I going with that? So
I know that problem. So let me ask you another question. And if you remember what it was you're going to say, feel free to jump back in. But so the law says that the court's supposed to provide for privacy and independence. So talk about that independent piece. What I understand, what they have to provide privacy. What does it mean for them to provide independence?
So
is that sort of what you're talking about with regard to I can petition the court on my own without being in the middle of open court?
I'll give you an example of my independence.
Okay.
Title II says that auxiliary aids and services include audio recordings and similar technology or services. So I asked for the right to record. And the court will come and say, we're going to record and you can purchase a copy of that recording.
Right.
And I say, no, I'm asking for this for disability mitigation. And so therefore you can't charge me a fee for my disability to be mitigated, period. You can't do that. And I'm letting you know that I don't trust you to provide an accurate copy of the report. And I don't need an official copy, but I need my own copy. And I need that because it's my usual and customary practice. And I've got documentation for this from a healthcare professional. It's my usual and customary practice to record my interactions with government. And so therefore, and this is, I mean, seriously, this turns into a standoff every time. And so in California recently, I just said, look, and I just keep putting in an email, this is a conspicuous notice that I will be recording, blah, 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 every time. And they don't like it, but I mean, I have to have it. And so, you know, is it going to be me getting charged with wiretapping, or is it going to be them getting charged with denying me access? I don't care. I really don't. My client will care, but my client's not doing it. I'll do it for my client. And so the piece that you told me I might remember a while ago was when a trial court administrator says you have to go in front of a judge. I say, no, you have to do that. Well, then that becomes a standoff as well. And I mean, honestly, the way to combat this is to go into federal court, sue them, and hold them accountable. And then there again, you have a situation where it's expensive and it's a big commitment, and yet people have got to do this. So That's what we're doing. It's everybody that goes into court. I'm just going to come out and say this. I've said this before. I believe everybody that goes into court can assert the ADA, because it's a situation where there's a construct put together that is intimidating, is threatening, it's coercive at the least for everybody. And at that point in time, when you talk about system 1 and system 2 thinking, you're going to be in system 1 loop, where you're in an emotional response of, I got to get out of here. I fight or flight. And you're trying your best just to get through it and get out of there. You're not in a space where you can think cognitively. You're not in a space where you can react appropriately. And you're probably going to react inappropriately. And then that's going to force them to say, not force them, but it's going to give them the opportunity to say, well, if you do that again, I'm going to hold you in contempt. And that's going to exacerbate the stress you're already feeling. I mean, it's a fire feeding itself at that point. And a lot of people, when they go into court, they're already emotional because they feel like they're being brought in there for something that they shouldn't have to be brought in there for. And I mean, who should have to fight for their kids to have time with them? Well, everybody does. And so when you go into court and you have to deal with this, it's a problem, because all of a sudden you don't have access to your cognitive space. And if you don't have an attorney, here's a double-edged sword. If you don't have an attorney, you don't have anybody speaking for you, because you can't speak for yourself effectively. And if you do have an attorney, the attorney is not going to stand up for your ADA rights and will probably tell you to even keep things like abuse hidden. This is a common practice. And so having an ADA advocate can change that. And I want to get more ADA advocates in court. I want to get more ADA advocates going into court and saying, you're not doing it right. I mean, because they're not. And so I'm up against a judge right now in Reno, Nevada. And this judge, she graduated in 1988, I think it was. And so that was before the ADA even came into play. And we're trying to get ADA rights. And I mean, she is stomping on this client and acting as if she's, honestly, the judge is acting stupid. And it's discouraging.
We have a few of those here.
When a judge,
I know.
it's awkward to say that this judge is acting unintelligently, and as if she's not competent to be even a lawyer, much less a judge. So, and this is something I run into quite a bit.
Yeah. You mentioned the recording as an accommodation you seek. What are some of the other examples of accommodations you seek? You don't have to talk about the disabilities, not that you're naming any names anyway, but just what are the things that clients who do find themselves in court, if they don't have an ADA advocate or don't have an attorney, or even if they do have an attorney, like you just said, and I can speak from the attorney perspective, you're right. We don't know. We don't get taught the ADA. So what are some of the accommodations that people can be seeking if they're in court right now, if they're in a legal battle for themselves?
So, if you wouldn't mind, put us up side by side on this one, because this is kind of going to be interactive here. So taking breaks, that's one, as needed. Having the ability to confer with your ADA advocate, because a lot of people, when they get into a triggered state, they need somebody to say, okay, here's what we're going to do. We're going to walk this back down, take a couple deep breaths. Why don't you hold your breath for a minute. Hold it for a second, let it out slowly. Get them to focus on something other than what they're going through, and walk them back through that. Like I mentioned earlier, having barriers in between them and their domestic violence perpetrator is one. Having the ability, and this is a sticky one. having the ability to ask the court for and receive a static, complete, permanent, and full meaning to any words or terms that are unclear or confusing to them. I don't know if you can tell this or not, but I have that memorized because it's one of mine. And I have it because of social communication disorder. And when you go into court, we've already talked about the fluidity of words. And before the segment started, we talked about how words, and especially words that are used in courts, have latent ambiguity in them. Thank you, Ed. Shout out to my buddy Ed for giving me that term, latent ambiguity. And this is something, and when you ask a court for this, what the ADA coordinator is going to say is, you can ask your attorney for that. No, I'm not asking my attorney to explain what the court is saying. I'm asking the court to explain what the court is saying. And I'm asking the court to order that the other side does not use legalese as well. And I mean, because, you know, you start throwing around terms like sua sponte and you know, all these other things that we don't have a clue what they mean. I mean, I know what sua sponte means, but yeah, you throw around terms like this that are common for lawyers, but uncommon for the average layperson.
Yeah.
And,
Yeah.
you know,
Language layperson.
it's just like talking Spanish in an English court.
Yeah.
You know,
Right.
So,
Yeah.
and I understand there's a guard around the practice of law, but I'm here to say it's not working the way it needs to for people to get justice.
Right. Well, and I think to Dawn's point too, the attorneys out there, they've got your case, the merits of your case on their mind, and that's what they've immersed themselves in. I mean, this is a whole separate area of law with a whole separate set of procedures and a whole separate set of everything. And yeah, most attorneys are not even gonna, they're like, that's superfluous to what it is that they think their job is, which is to win your case or defend your case on its merits. And so I think that, yeah, most attorneys, this isn't even going to be on the radar. And if you put it on the radar, they're going to be like, I don't have time. Like, that's not, it is superfluous to what I'm trying to do. And yeah, so I think this is definitely one of those areas where bifurcating your rights under the law having to do with the merits of the case and your rights under ADA are definitely something that needs to occur, because it really almost is, what I want to say, what you're trying to accomplish as far as ADA rights are almost diametrically opposed to what's happening in the courtroom. And I think you've really alluded to that without saying it that directly, Jay.
That is a, you know, I thank you. That I've never heard anybody bring that out in a way that caused me to have. So trust law. Trust splits title into two parts: a legal and equitable title, or a legal and beneficial title.
Yeah.
And so with this, that's kind of the same thing as far as you said bifurcating your rights. Well, you have ADA rights, and those are not going to be handled by an at-law attorney. They're just not. But the second thing is, even they're also seeing it as a distraction to the substance of the case.
Right.
They're also seeing it as a fear piece, because they don't want to have to go up against a judge and say, well, judge, we got to do this differently. Even doing it differently, just saying the words doing it differently is like, what kind of tricks are you trying to pull today, counsel?
Right.
Yeah.
You know, I mean, this
because they fear the judge too. I mean, the attorney goes in there with trepidation, knowing that they've got to dot all their I's and cross all their T's and be on their best behavior, or they're going to get sanctioned. So you've got a situation where, again, they're advocating for you to a point, right? But they really, like you said, can't get down in the weeds and down and dirty in the mud, or they're gonna risk a lot too.
Well, and it's not even so much the sanctions, the personal sanctions. It's even, first and foremost, it should be, or would be for me, it would be my client's case. If I piss off this judge, you know, it's something, he's going to do something to torpedo my client's case. And so there's, you know, even, you know, there's that balance there where it's still trying to put the client first. But like you just said, their ADA rights could be in direct conflict with the merits
Right.
of their case.
Right.
So that is a viable,
Conflict.
conflict.
Absolutely.
That,
Yeah, one example of that, Dawn, is when as a lawyer comes in and starts doing the at-law piece, and the other side says, well, I think they need to have a psych eval. And I mean, I can't tell you how many times psych evals are disproportionate. So one side will say the other side needs a psych eval, and the judge will say, okay,
yeah,
we'll get them a psych eval. And it may be because this side over here has custody and this side over here is wanting custody. And this side says, well, before they can do that, we need to get them a psych eval. Well, why doesn't this side need a psych eval? Because
right.
once that's put on this side, they're regarded as disabled until they prove otherwise. That's just how it is.
Yep.
And so the lawyer over here is going to be like, well, you better do this because, I mean, we got to show the judge good faith and blah, blah, blah. And that's substance of the case stuff. It has nothing to do with ADA. And they're not going to go for it. They're not going to go for that. So it's a quagmire.
Yeah,
I was going to say quagmire.
And one of my,
I knew where I was going with that.
yeah,
I did.
So
one of my other questions to you, Jay, is, I mean, I get the sense that you work with attorneys and then you work cases without attorneys. I mean, which is better? What's the solution here? Is the solution, hey, let's get our attorneys up to speed? Or is it, let's equip people to do this on their own without attorneys as best they can? Or is it both? Or, what's one of the solutions here?
So one thing I'm working on right now with y'all is getting a CLE piece put together.
Yeah.
And yes, we want attorneys educated because there are ways and there are increments of ways that attorneys can use the ADA to benefit themselves and their clients and to augment their services. One of the examples I'll give you is a case that I was on and still, basically on. I'm kind of hanging out in limbo, waiting to see what happens, all that stuff. But what the guardian ad litem came in and was given notice. I think we may have talked about this before. I don't know if we talked about it on these segments, but the guardian ad litem was given notice that the child had a disability due to a hygiene issue with the parent that was not cooperating. And the guardian ad litem did not include this information in their report. It kind of ignored it. It was given information about the doctors, given information about the emergency room visits, the medicine, ignored it. And so the attorney that I was working with on this case said, let him have it. And this guy, I mean, he's even afraid to go after the judge. But in this case, he's like, that's what we got. We got to play that card. So I wrote a letter, told the guardian ad litem, you don't have immunity. You can be held liable for this. And actually, you're supposed to be a mandatory reporter. What you could be doing is I'm not saying that it is, but I mean, it appears that it could be.
Yeah.
Violating
that
criminal stuff.
Yep. Yep.
And so this guardian ad litem immediately moved to withdraw from the case. It scared him. And I told the judge, you're overseeing this and you're letting this happen, so you're liable as well under Title II. And the judge got pissed and threatened the attorney with possible sanctions, just like we saw in that video that we just looked at. Well, and he said, no, I'm not going to let him withdraw. We're going to have a hearing. And so he didn't let him withdraw. So the guardian ad litem comes into court, has his own attorney, and says, I plead the fifth to all your questions. And the judge said, and that's an officer of the court doing this.
Yep.
And so the judge said at that point, says, I have no choice but to pull you from the case and we'll pull the report too, which is what we wanted. But the reason we got it is because it was right. And the attorney couldn't do this by himself. The attorney couldn't go in there by himself and do that. I mean, he was already threatened with sanctions. Who knows what he would have been threatened with if he had done it without an ADA advocate saying, this is what's going on.
This is the law. Yeah. Yeah.
So,
well, and And I could say that too in the education piece, right, is to show attorneys how to use it and not make it diametrically opposed to the merits of the case. I think that's a perception that can probably be overcome, right? You just weave the rights into your case so that it's one stronger case. Because that's what we're saying, right? Is these people don't have access to justice. Justice is the ultimate goal, should be ultimately what we're seeking. So anything that helps get us on that path to justice shouldn't be.
Yeah, and to get attorneys to realize that how this benefits them in their case.
Yeah.
Right.
In
most cases. In some cases, it's not going to if you're on the other side of this trying to fight it. But
I was talking to someone this morning, and have you heard of Munchausen by proxy?
Yes.
Okay. Mm-hmm. So the DSM-5 calls it factitious disorder imposed on another, and but we know it as Munchausen by proxy when I would say or do things that would cause someone else harm. Okay, like my kids, or for instance. And so sometimes this can even be inferred, and if this is inferred, such as the child is worse off with this parent because this parent is actually doing things that could possibly harm the child, an attorney can use that as a regarding as disabled and the parent's being discriminated against. This is an open play,
right?
And so it's being overlooked. It's being it's very underutilized. I use it as a social engineering tool, and if attorneys did this, they would also have a better edge on their ability to sustain their business monetarily, even though the monetary piece is not with the ADA as far as punitive damages. There's a social engineering piece that will accompany the monetary piece and will assist them in making their practice more profitable, in my opinion. I'm just a high school dropout. What do I know?
Well, and you mean that it makes their cases successful. It gives them a better chance of succeeding.
It's another tool in their box.
Yeah.
Absolutely.
Yeah.
So,
which would be good for clients and attorneys.
Yeah, if we could build a bridge between the legal industry and ADA rights, then the absolute corrupt power that the courts have, could be reined in a bit, and in a way that could protect a lawyer, because if a lawyer is going to come in and aid and encourage someone in the exercise and enjoyment of their rights, they have federal protection under the ADA as well. And it's going to take a lawyer with some cojones to do this, but the bottom line is, if a lawyer goes in and says, "Judge, you have to give my client ADA rights," and the judge comes back and says, I should sanction you for even suggesting this because we're not playing that game here today. Well, at that point in time, there's coercion, intimidation, threats, and interference on the person, the lawyer, that attempted to aid and encourage the exercise and enjoyment of rights. And that's another breach that the judge does not have immunity for. And really, it's so much of what I do is counterintuitive. I had somebody ask me this morning, if I say that I have a disability, can they use it against me? Well, it's counterintuitive, because if you say it and you assert the rights of the ADA, for them to come back and say, well, now we need to know if this disability is causing them to have, and I've got a case in Kansas right now where the lawyer said, now we need to know if this disability is causing them a problem parenting their child. And I said, oh, thank you for saying that, because that's flat out discrimination.
That's right.
And so they shut up after that.
Yeah.
So
I think there's a couple of things maybe it might be worthwhile to explain again. You've used the phrase "regarded as" a couple of times, and so I think that's important to reiterate here in this context where we're under Title II in the courts, or in public accommodations, that regarded as means you don't necessarily have that disability, right? But you're being regarded as and treating as though you have it to your detriment.
Yes.
And we've talked about that in the employment context. So it's kind of the same concept here. I just want to make sure we, reiterate that too, in case we have some new viewers and new listeners. But, and then something else you said, the train left the station. I can't remember.
The regarded as piece. I mean, I've even had judges order clients to get, or litigants to get a certain vaccine.
Sure.
And that in and of itself is regarding them as being disabled, because they're regarding them as either being a direct threat or having a disabled immune system that can meet and or defeat that specific contagion.
Yeah.
But the other regarded as pieces are like when they say you have to get a psych eval, or if they're alleging that the child is worse off with you. And here's something else. I mean, I've got a case right now where a child has reactive attachment disorder. And this is something that makes a child unable to really communicate well. And if there's a parent that the child is used to being with, and that parent is yanked from that child's life, then that child has a disability that's not being addressed by the court.
Mm-hmm.
And so the children have disabilities in this thing too, and or can be regarded as disabled. All of this can be brought into play for the child as well. There's a case I'm involved in right now, and I sat in a meeting the other day, and the attorney's like, "Well, we're here to talk about the parent. We're not going to talk about the child." I said, "Hold on, the child has ADA rights too." And the attorney went,
Shocker, huh?
and turned red. And I mean, it was just, and asked for more time to talk after this call was over. And yeah, so, and I've still got my letter to go out to her, but it's going to, I mean, people are being denied ADA access, period. Mm-hmm. ADA advocates can help change it. Lawyers can help change it faster, but they have to be trained on know how to do it. And ADA advocates can help with that. I work with attorneys. I work against attorneys. The choice is yours.
I think judges need to be educated too. I mean, this is definitely a situation where I don't think most judges even give up flipping.
Well, and what are most judges? Lawyers.
Yeah. But I'm just saying that in terms of, you can educate the attorneys, but if you're running up against these judges that are just whatever, right?
Exactly.
It's going to be, I mean, we want to make this whole system more accessible to everybody. And I think that definite piece, how we do that, hopefully through the CLE. But I mean, there's who do we need to approach to say, hey, let's make sure everybody's getting the same message and understanding what everybody's rights are under this, so that this doesn't have to be a big deal when we go into court. We can address the merits of the case, which is what everybody wants to do for the most part. So
yeah, there's a judge right now that I have that I'm advocating for client for ADA rights, and the reason that the client has ADA advocates on this case is because this judge actually told this client, who's a woman, and the judge is a man, and so there are not the stereotype, but the fact is there's a power differential there, period. And when the judge tells the woman, I'm going to hold a gun to your head, that's unreasonable. And so we're definitely going after this. So
that's abusive. I mean, that's not just unreasonable.
Oh, it's just a figure of speech. Come on now.
Sure.
Yeah. That's why we can go into court and do that to judges all day long and walk out and smile about it.
Right. Exactly.
Right.
Not going to happen.
Yeah, that doesn't happen. Nope.
Yeah.
So, I said that I was going to be able to talk for the whole hour, but we may need some questions if there are any questions. I don't know if there are any, but let me know.
That was very informative. Thank you so much. And I like the questions, Dawn, that you're bringing to the table as well. So we've already had this built-in Q&A. So thank you. Okay, let's see here. We have quite a few. I think you may have touched on this a little bit, Jay, but the first one here is, can judges throw out cases and decide to not hear them?
I'm not sure what that's based on.
So a case has to be, he used the phrase sua sponte, which that's what this means, right? On their own, in their own accord or in their own power. A judge typically is not going to be able to throw out a case, what we call sua sponte, without a motion of a party. So a party can move the court to dismiss a case. But most of the cases that Jay's talking about, or a lot of them are family law cases, they're custody disputes. The court's not going to be able to throw those out without making a decision. Like that's how they deal with them. That's how they dispose of them, is by making a decision, one way or the other.
Okay, great.
I want to make a point before you go to your next question too, that people in criminal cases have ADA rights as well.
Ooh.
So if you're in a criminal case and you're asking for ADA access, prosecutor doesn't have the right to breach your privacy. So just letting you know that if you're in a criminal issue.
That's a very good point. And with criminal cases, there will be attorneys, right? Because if you're charged with criminal charges and facing jail time, you have the right to have an attorney appointed to you. So definitely have that conversation with your attorney. And perhaps it's a matter of saying, hey, I want an ADA, advocate with me. If the criminal attorney doesn't have the expertise or knowledge, maybe you ask for an ADA advocate.
Great. Thank you, Dawn. We have another question here specifically about collateral for websites and digital media. So how does the ADA affect websites and digital media, and what is necessary actually to have up there?
Go ahead, Jay.
So before I get into this, my area of focus, lawyers will focus on family law or trust law or criminal law. My area of focus is usually on invisible disabilities. And even so, the website piece is something that I have not focused on yet because it's not something that calls a lot of my attention. And therefore, I have to go where the fire is. I put the fires out. As far as websites, though, there are things like readers for people with vision or hearing impairment. The readers would translate into TTY for someone with hearing impairment, and there are other ways that they can interact with websites. I'm doing a ham-fisted job of answering this, but there's a lot of technology that can be used. There's a minimum. I actually host. I talked to someone, and we all know someone that does website accessibility, and Jeff. And so I talked to him about my website, and I told him, I said, the reason I have my website hosted on GoDaddy is because GoDaddy offers a minimum of accessibility that meets the standards, and that way I don't have to focus my efforts on making it an extra level above, even though I will at some point. It's even for me as an ADA advocate, I have to put fires out, and what I'm trying to do is focus on doing that. So with website accessibility, it's a broad spectrum, and if you don't have accessibility, pursue it, ask for the accommodation, and if you don't get it, there are ways to pursue filing complaints on that and following up on it.
Great. Chris or Dawn, anything you'd like to add?
No, that sounds good.
Okay. So another question that's come in: how does OSHA play into the ADA? And I believe that we did touch on this in an earlier episode, but we have another question here.
I think the first episode was
two separate things. Yeah, I think that's a Title I issue. And I think they're two separate things.
Okay. Thank.
Yeah, OSHA is its own administrative body. They have their own adjudicative function. There can be some overlap, but for the most part, I know actually with the COVID vaccine stuff, there was some overlap between OSHA and all that. But for the most part, there's not usually a tremendous amount of overlap. Dawn, do you have a different experience?
Yeah, I think it's just, OSHA has its purpose for make sure employers are providing safe work environments. ADA is making sure people with disability are not discriminated against and receive their accommodations. So to the extent they do overlap, you would have to do some analysis, because one doesn't automatically trump the other. But you would try to preserve both, workplace safety and ADA rights. And that could be a challenge. But
yeah, the employers are going to try to hide behind the OSHA.
Right.
That's probably everything. So you're going to have to understand how that dovetails.
Kind of like judges and judicial immunity.
Exactly.
Well, that's probably where this question arose from, is just the times that we are living in right now with this specific topic with the vaccines. So I can see how there would be some overlap there in that specific situation. Okay. So and this is a good one as we kind of close this out. Jay, you kind of expanded on this at the beginning, but Chris and Dawn, your examples here are, what is the most important ADA case that you've advocated for or that you've worked on from the legal perspective for setting a legal precedence? If there's something, one that comes to mind that you'd love to share a little bit about from each of you.
I'll jump first if that's okay. I got 3 cases right now that I'm trying to get into federal court. And all of these are judges actively denying ADA access for clients after they've been repeatedly asked for accommodations and modifications. And even it's just astounding the level of shell game that they will go to deny someone equal access. And Tennessee versus Lane, the dicta of that case talks about how people trying to get access to state and local government services has been an ongoing problem, even though there have been numerous laws to combat it. Yeah. And it's worse today, and it's going to continue to get worse until somebody comes in and says, okay, how about we just get rid of judicial immunity? How about we get rid of that? How about we add punitive damages to this? How about we restore people to the place where they were before they started having to deal with this? And a lot of times you can't prove compensatory damages. You can't. I mean, and how are you going to prove mental anguish? I mean, if you've already got somebody in front of you, I mean, seriously, it's an abusive process to even have to go after these things. So anyway, I rambled.
Chris or
so one case that comes to my mind, I was actually on the employer side. This is when I worked for the government. But what it did was it really focused me in on what people have to prove with regard to reasonable accommodation. And I had a case where the person, I think I might have alluded to this in the first episode too, that this person had a disability that was not, it was beyond, it wasn't, even if we could accommodate him, he was not going to be able to do the essential functions of the job. He had been promoted above his means, not, basically because the government tends to do that sometimes. And so, but it really focused me in on really that piece of it, what he had to prove, what we had to prove, and just sort of, like I said, honed that in for me. The most recent thing is something I'm working on with Jay, and this whole issue having to do with the ADA versus we're talking in the education system, that they want to hide behind the Rehabilitation Act, Section 504 for everything. And they do not want to at all even acknowledge the ADA portion of it. I happen to think that that's because their whole entire house of cards has been crumbling down when they do, right? And I think it hasn't been challenged in court yet because nobody has known to really challenge it. And so we're hoping we've got a couple of cases set up to be actually get some case law and challenge that particular aspect of these things where the education system is trying to force people, mainly have to do with vaccines, childhood and or COVID, but not recognizing at all that there is an ADA portion of that when someone exerts it, their rights. So there isn't any case law on that. I think there needs to be, again, like Jay's saying, you got to get some of this stuff on the record and get the courts to rule on it. So those are my two experiences.
Thank you, Chris.
I want to say too that we talked about Title II today. This applies to school stuff all across the board. Title II, the ADA Amendments Act of 2008. What it did, it became the new legal standard, and schools are still operating largely under 504 only, not even considering the fact that they have to give accommodations without extensive analysis, and that they can't coerce, intimidate, threaten, and interfere, and that they don't have immunity. Under 504, there is no removal of immunity. And so if you invoke the ADA, if you're in a school situation and you don't invoke the ADA, you're losing out on a great number of rights. And you should definitely use it. And the first thing they're going to do is try to ignore you and or sweep it under the rug. So just keep saying ADA, 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 ADA.
Yeah, and they'll go la 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 la. I don't hear you. Yeah, it's
writing.
Amazing.
Do it in writing.
Writing. There you go.
It's really amazing that they're just stick their head and they don't even want to address it. Well, which again just tells me that they know that once they address it, it's over. They're not going to be able to hide.
Once they address it.
Yeah.
Well, and that's what we're talking about. And with all of these things, with the courts, with whatever, if they've got their rules and their processes they follow, and you try to come in with something out here, they're like you just said, la 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 la. Yeah. I don't hear.
Yeah.
And they think, out of sight, out of mind. If I don't acknowledge it, it doesn't exist.
Yeah.
So we just got to stay at the door and keep knocking and keep pounding.
Yeah. And finally kick it in.
Seems like the powers that be, so to speak, always want to ignore at the beginning, right? This is a theme. So
it's a power, it's a power. They do have people completely confused. Most parents aren't going to go to the Department of Education website and read it and see that it specifically tells schools that they must change their policies and that they must adhere to the new legal standard, which is the 2008 amendments, which significantly broadened the access to the ADA.
I even had an administrative judge here in Texas say she could not rule on ADA. that was outside of her jurisdiction.
Oh my goodness.
Wow.
So that's what we're up against.
Yeah. Wow. Well, thank you to each one of you for joining us today. Thank you, J.V. Shore, Certified ADA Advocate, Chris Pizzula, JD, and attorney Don Uballe. We appreciate your time and your expertise. And thank you to our Vax Choice community for joining us. We're here every Thursday, 1 p.m. Eastern Time. You can find us at Vax Choice on CloutHub and all other social media channels. Please join us at vaxchoice.com and subscribe to our newsletter. And once again, this has been hosted by Disabled Rights Advocates. So none of the information here is legal advice, though if you are looking for some legal assistance, please do visit dradvocates.com. Now, we'll be back next week with another subcategory under the A to Z Guide to the ADA. Thank you for joining us for the court, and thank you again for being here. So we'll see you soon.
Thank you.
Bye, everybody.
Bye.
Mm-hmm.